Welcome back to The Explainer. So, today we're tackling the federal rules of evidence. Now, I know what you might be thinking, a dry, giant list of legal codes, right? Actually, scratch that. It's way more like a high-stakes survival gauntlet for courtroom evidence. If you've ever wondered how lawyers literally get that smoking gun, that vital document, or that shocking confession in front of a jury, well, you're in exactly the right place. We're going to see how every single piece of evidence gets relentlessly filtered. Okay, let's dive into this. Getting evidence admitted is a strict sequential process of elimination. We're going to navigate the admissibility gauntlet, figure out is it authentic, avoid the policy and character traps, work our way through navigating the hearsay maze, and finally, look at privileges and impeachment.
Starting right off with Section 1, the admissibility gauntlet.
Before a judge even cares about who said what, or if a document is a total forgery, we have to ask the absolute most basic question. Does this actually matter to our case? So we're starting at our very first filter on the map, relevance.
Under Rule 401, relevance is honestly a remarkably low standard. To survive this first test, the evidence just needs to have any tendency to make a material fact more or less probable. It just needs to help prove something, literally anything about the case. The burden here is not beyond a reasonable doubt or even a preponderance of evidence. It's just, does it move the needle at all? If yes, it survives step 1. But, survival is brief.
Now, what's really interesting about this next filter is that even if evidence is relevant, a judge can still toss it out under the Rule 403 Balancing Act. The judge has to weigh the helpfulness of the evidence, its probative value, against its potential to cause unfair prejudice, confuse the issues, or just waste everyone's time. Like if a gruesome photograph is only slightly relevant, but so shocking it might make a jury stop thinking logically, the judge will absolutely block it. It fails the gauntlet right there.
Which brings us to Section 2. Is it authentic?
So, your evidence survived the relevance test? Awesome, but you absolutely cannot celebrate yet. Now we have to focus on the physical reality and the actual origins of the evidence we're holding in our hands.
Under Rule 901, the party offering the evidence simply has to account for how they got the item. It's really just a common sense showing. If you're standing there claiming this is the weapon used in the crime, well, how do we know? You can prove authenticity through a documented chain of custody, matching serial numbers, maybe police initials etched into the item, or really any unique markings. You just have to prove it's not some random stand-in.
And if that piece of physical evidence happens to be a document or a recording, boom, you hit the best evidence rule. If a witness is going to sit on the stand and testify about what a specific document says, they generally need to produce the original document. Now, duplicates are usually totally fine if there's a good excuse, like, say, the original was destroyed without any bad faith, but you can't just rely on someone's memory of a contract if the contract itself is mysteriously missing.
Moving right along to Section 3, policy and character traps.
Okay, let's see how this builds. Your evidence is relevant, and you've successfully proven it's authentic. But now it enters highly strategic, honestly dangerous territory. Because even if evidence is totally real and relevant, society might still want to hide it from the jury.
See, the law generally hates propensity evidence. You can't just use prior bad acts to say, look, he's a bad guy, so he probably did this bad thing. That is a massive trap. However, Rule 404B gives you a bit of an escape hatch. You can use specific prior acts if they prove something else, like motive, maybe being down 20 grand in gambling debts right before robbing a bank, or opportunity, like knowing the exact layout of a building security system, or famously, a signature crime, kind of like the wet bandits leaving the water running at every single house they rob.
And this brilliantly illustrates the massive divide between criminal and civil trials when it comes to character. In a civil trial, propensity character evidence is basically dead on arrival, completely inadmissible. But in a criminal trial, the defendant actually holds the keys. If the defendant opens the door by presenting evidence of their own good character, well, the prosecution is suddenly allowed to rush right in and present evidence of their bad character. Beyond character, we've got these strict public policy exclusions. Think about it. If someone slips on your icy sidewalk and you immediately buy rock salt to fix it, Rule 407 says that act of fixing it cannot be used against you to prove you were negligent. Why? Because society wants people to fix icy sidewalks. We want people to offer to pay medical bills, and we want parties to negotiate settlements out of court. If we let that evidence into a trial, nobody would ever fix a hazard or try to settle a case.
All right, stepping into Section 4. Navigating the hearsay maze.
So our evidence has survived relevance, authentication, and those really tricky policy traps. It now faces the biggest boss fight of the entire gauntlet. Remember, we only even reached this stage if the evidence wasn't thrown out by those first 3 filters.
Let's break down this incredibly dense legal jargon. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Basically, the court absolutely hates secondhand gossip. Why? Because the person who actually made the statement isn't sitting on the witness stand to be cross-examined. You can't test their memory, their perception, or if they're even being sincere.
But keep in mind, not every out-of-court statement is hearsay. If someone yells, "ouch," or says, "I smell weed," those aren't tricky, calculated assertions. Ouch is literally just a physical, reflexive reaction. I smell weed is a present sense impression of a physical condition. If a statement isn't meant to assert a fact that we're actively trying to prove is true, or if it has its own independent legal significance, like the words, "I accept your offer" in a contract dispute, it bypasses the hearsay maze entirely.
But what if it is hearsay? Well, then you're going to need a golden ticket, an exception. These exceptions all share one big common theme: extreme circumstantial trustworthiness. A present sense impression made within 5 minutes of an event. An excited utterance made while someone is still under the stress of a startling stimulus. A dying declaration, because historically, courts figure people don't want to die with a lie on their lips. Or business records, like a 7-Eleven credit card receipt, because businesses literally rely on accurate records to survive. If you have one of these tickets, your hearsay survives.
Which brings us to our final stop, Section 5, Privileges and Impeachment.
We have made it to the final hurdle. The surviving evidence faces its absolute last test before it can finally be handed over to the jury. Now we have to look at who is talking.
Privileges act as an absolute shield. Under Rule 501, the law recognizes that some relationships are just so sacred that protecting them is actually more important than finding the absolute truth in a courtroom. Think attorney-client, spouses, psychotherapist-patient, and clergy-penitent. Even if a confession is incredibly relevant and perfectly authentic, if it was whispered to a priest or a lawyer in confidence, the gauntlet stops it cold. No way is it getting admitted. Finally, if a witness does make it to the stand, they can be impeached, meaning their credibility is attacked, but they can also be rehabilitated. So the crucial point here is timing. Imagine a witness testifies on August 1st, and the opposing lawyer accuses them of taking a bribe on July 1st to lie. You can actually rebuild their credibility by showing they made the exact same statement way back on June 1st, long before they ever had a motive to fabricate the story.
And just like that, the evidence has either been completely destroyed by the rules, or it's survived the gauntlet to become part of the trial. But it leaves us with a really fascinating question to ponder. After all of these incredibly strict filters, relevance, authentication, policy, hearsay, and privilege, does the jury's final verdict truly reflect the absolute objective truth of what happened, or does it merely reflect the best, legally filtered version of the truth that society is comfortable with? Thanks for joining me on this explainer, and I'll catch you next time as we continue to break down the complex systems that shape our world.